Good morning, everybody, and welcome to today's webinar. Today, as you can see on the screen, we're going to be talking about privacy on purpose, navigating the 2025 amendments in New Zealand and beyond. Thank you so much for making the time to join us today. I hope that you get a lot out of today. There's some really interesting movement in the privacy and data protection space happening not just in New Zealand, but around the world. We'll be touching on some of those key elements today. But before we go any further, I would like to move on to the next slide and introduce my co-panelists. My name is Michael Nelson. I'm the Senior Product Specialist for the Regulatory Compliance Solution with LexisNexis. And I'm joined today by Kieran Seed and Rohit Nayak. Kieran, would you give a quick introduction?
Thanks so much, Michael. Hi, everyone. Good morning and afternoon if you are joining us from over in New Zealand as well, or wherever you happen to be listening today. As Michael mentioned, I'm here and I head up the content team for the regulatory compliance solution at LexisNexis, everything related to our content creation initiatives, content currency, as well as our tracking and notification of regulatory changes in a variety of different jurisdictions flows through my global team. So very excited to be joining the panel today and to participating in the discussion.
Thank you, Kieran. And Rohit, maybe a brief introduction on you.
No, thanks, Michael. Yep. Hi, everyone. I'm Rohit Nayak. I'm the Principal Solution Designer for Diligent for the APAC region based out of Sydney. My role involves understanding regulatory trends across our region and working on customized solution using our GRC products to meet our customer needs. I have over 18 years of business consulting experience, most of which with the Big Fours around audit, risk, and compliance management, including privacy, and I've helped several organizations globally across sector and industry in implementing fit-for-purpose compliance solutions. So really excited to be here.
Thank you very much, Rohit. And of course, when we share the deck, there are some QR codes that you can use to get a little bit more information about everyone who's on today's panel. So as you can see from this, today we're going to be covering off on a range of different issues. We'll a little bit of housekeeping to begin with, we'll get to in a moment. But if you do have any questions, there will be hopefully time to explore any of the things that you might want to raise and discuss in further detail towards the end of the session. But first, we might move on to housekeeping. Today we'll go on for roughly an hour, either side. Not too much either side. I suspect we've got a lot to cover. As I mentioned, any questions, please use the Q&A tool in Zoom. And scattered throughout today's demonstration, there will be QR codes that will give you links to some, what we hope will be some really interesting supporting material that'll give you, I think, some different angles on some of the topics that we'll be discussing today. Now, we might move on to who LexisNexis Regulatory Compliance is, first of all, and then we'll invite Rohit to talk a little bit about diligence. For those who don't know, LexisNexis has been around in various guises for the best part of 2 centuries. Predominantly what LexisNexis does and has done for the best part of those 200 years is legal research. About 10 years ago, we moved into the space of regulatory compliance with the understanding that the people who are very good at understanding and interpreting legislation and case law would also be very good at understanding legislation and regulation for the benefit of people who work in risk and compliance. And so from that, we created, and largely due to Kieran and his team, a wide variety of different obligation registers that give you an insight into not just what you have to do, but what best practice looks like as well. We've also got associations with regulatory change that build in insights into what's happening over the horizon, and then when those over the horizon changes loom imminently, what those mean for you and how you can interpret those through the lens of the obligations that you've identified as relevant in the registers. We've got a wide variety of content across Australia and New Zealand, and increasingly in other overseas jurisdictions as well. Most recently, with particularly relevant for today's purposes, GDPR in the EU and all of the benefits around privacy management that flow from those. Now, what I might do is pass over to Rohit to give you a brief introduction as to who Diligent is and what their solution provides.
Thank you, Michael. So Diligent is a modern governance company. As a leading GRC SaaS company, we serve over 1 million users, over 25,000 organizations, and over 700,000 board members. Diligent One platform, as you can see from that image on the right side, is basically a platform which has designed to revolutionize the way boards, committees, and executives navigate risk. Its scalable and expanding set of purpose-built application power every risk and compliance management program for your organization. As you can see on this other side, we have integrated view of audit, risk, information security, ESG, ethics, and compliance all on a single platform. And that's one of the reasons why Diligent is one of the preferred solutions by 80% of the Fortune 500 and almost 90% of ASX 200 to elevate their strategic risk and governance, as well as implement regulatory compliance programs.
Thank you very much indeed. And you can see why the synergy of the LexisNexis content and the Diligent platform has the potential to work really well for you. So I guess the first question that we need to ask ourselves when we're looking at these changes that have been under discussion in New Zealand for a little while now around an enhancement to IPP3 is what's driving this extra step in what's been, I think, a relatively established framework for a little while now. In a way, it's akin to what's happening with the Australian privacy principles, but of course, it has a particular New Zealand spin. What I might do is invite Kieran to talk a little bit about what's led up to the amendment and why we're all talking today.
Thanks so much, Michael. And funny you should mention, obviously, the Australian context, because it does create a bit of an interesting, I guess, narrative in terms of the transition, these regulatory changes across jurisdictions, and perhaps we'll touch upon that a little bit more in greater detail later in the session. But firstly, in terms of what's led us to where we are today. So before we dig into what are we actually talking about in terms of the amendment, we need to understand, the why, like what's actually taken us to this point. So the introduction of these changes that we're going to talk about in relation to IPP3A in particular, they stem from a couple of key factors. And the first of that is around clarity and transparency. And it's been, I guess, a key consideration that there's insufficient clarity at the moment in terms of how personal information is being collected in New Zealand, where that is gathered indirectly. And that gap needs to be addressed really to ensure that looking at broader society and community, that people are made fully aware in terms of how their information is handled. Another key consideration is around EU adequacy. Now, the European Union, during its assessment of New Zealand's EU adequacy status, identified that the practice of indirect collection, as I mentioned, indirect gathering, is a bit of a weakness in the New Zealand framework. So retaining EU adequacy is actually quite important because it enables New Zealand businesses to receive EU data in a seamless way. So by introducing IPP3A, New Zealand is able to close this gap and further demonstrate its commitment to robust privacy protections aligned to international standards. Now, it's been a few years now since the New Zealand Privacy Act 2020 came into force, and there have been a couple of technical issues that have surfaced during that time. So these amendments also do address those challenges and make sure to refine the overall personal data protection framework. Now, through this also, the changes will result in clearer guidance for agencies and organizations on operationalizing these requirements in particular, but also understanding how they play against other privacy principles. So what we can expect based upon the consultation, the rigorous consultation that's gone on so far, is for the Office of the Privacy Commissioner to continue developing dedicated guidance to assist businesses and agencies with these new requirements. And then finally, and I did touch upon this before, it's really about modernizing the privacy framework. It's part of a broader initiative to update privacy laws for today's digital world. And we'll touch upon a few of those other amendments today, but really it ensures that the legislation not only addresses current gaps, but that it aligns with evolving international privacy standards on the global stage.
Yeah, brilliant. Thank you, Kieran. I think it's one of the things that we're becoming more and more alive to, particularly in reg compliance, is that where we used to be, I guess, standalone jurisdictions, we're becoming more and more part of a global view around what best practice might look like. And I think as organizations, and honestly, I think elements of this were surfaced when we experienced the pandemic a couple of years ago. On the obvious side is the interruption to, global supply chains. But one of the things that became readily apparent is the increasingly interconnected nature of the way that corporations look to when jurisdictions look to the way that other jurisdictions might deal with a particular issue. And of course, increasingly, organizations operate across jurisdictions, and understanding the really complicated interplay between those requirements is becoming more and more of an issue, both for organizations that only operate internally but are still affected by the way that a jurisdiction might look to someone else to see how it's done, but also the way that an organization that might trade globally has to consider a whole variety of different legislative and regulatory sources when they're trying to work out what good is. So I guess that leads up to the next point, and if we might move on to the next slide. The question is, although IPP3A has been under discussion for a little while, I think that, particularly in this space, there's so much going on a day-to-day basis that sometimes taking the time to step back and poke your head up above the parapet to see what you need to start doing now in order to get ready for what's happening tomorrow, that can sometimes be a bit of a challenge. So I guess the question that I'd like to sort of put to panel is, what have you seen in terms of preparedness for 3A? What I might do is invite Rohit to look at what you've seen and what we can do in terms of helping organizations get ready.
Thanks for that. So let's unpack IPP3A notification requirement a little bit more. Now that you've heard why it was introduced, what was the need behind it? So in simple terms, Michael, when you collect personal information for someone other than the individual themselves, you must notify them in reasonable time, which is what we call indirect collection of information. Now, this isn't optional with this regulation coming up, and failing to notify can trigger legal penalties, reputational damage, financial loss, and trust is paramount. What we're saying is the simple rule is trust equals, transparency equals trust. So, and that's very, very, very easy to lose. And hence, with the upcoming regulation, what businesses must be preparing for is what does this notification cover? Now that we know that if we were to get indirect collection of individual information, one is, the personal information was collected. So just the notification to those individuals should cover this aspect that the information was collected. What was the purpose for this collection? Who are the intended recipients of this data? The agency's name, address, collecting the information. So it's the information of the agency who's collecting and passing it on to another business, be it marketing or a third party, and whether the collection is authorized by law. And most importantly, I think the individuals have a right to access and correct this information. So I think that's very critical. So the principle recognizes that individuals have a right to know when and why their data was collected, and even when it's done behind the scenes. So that's an extension of IPP3 rule, which is more direct collection of information. So this is also covering that indirect collection. But having said that, there are some exceptions which we need to also take into account, because in what circumstances would notification not be required? One, that it's publicly available, individuals are already made aware. But what we need to understand here is the collecting agency. And this is pretty critical, because if I'm the collecting agency as a business and I'm relying on an exception then I should ask for an evidence that and not make an assumption that the individual is already been made aware, which means that if I'm getting an information from a third party source or the disclosing agency, I need to do two things. One, I need to collect evidences that whether the individual was made aware and not assume. And second is also have a contractual agreement in place, the right terms to make sure that they are made aware of their obligation. Now, the other exceptions are whether disclosing or notifying will impact or is prejudice to national security or can reveal a trade secret, or it's a serious threat to public health and safety. So these are the things. But another aspect to consider, which the guideline has provided, is whilst disclosing this information, we should be reasonably practical that the cost of informing is not disproportionate to the benefit of informing. So that's something that is something that we need to consider as businesses. Ultimately, it's all about improving transparency and ensuring that individuals are empowered to exercise their privacy rights, right? So if you're collecting information indirectly, you need to be clear about who are you collecting from, why, how are you going to use that information, and the information must be accessible by the individuals themselves. With that, I'll pass it on to Kiran to talk about how do businesses prepare for this.
Thanks so much for that, Rohit. I think that the key thing is that with IPP3A and really any regulatory changes like this, it's important to prepare in advance. So even though there is a bit of time before we do see this come into enforce, having that proactive change management and preparatory steps being taken is ensuring your businesses are set up for success. So there's a couple of key steps that I would go through. The first thing I will note is that it's an ongoing process. I think the imagery is pretty clear around this. It's an ongoing process to consult what resources are available to you internally within the business, but also externally. And also just make sure that you have that really effective stakeholder network within the business in terms of how you roll out particular changes. And I think this is something to kind of call out at this point, because regardless of what change we're talking about today, having that really effective, engaged stakeholder process is going to be really important in terms of how you do roll things out. So how connected are your data teams, research and evaluation teams, delivery teams on how you're actually enforcing particular changes? And I will say that as part of the preparation for this, we know that there's plenty of resources that are already available out there, whether it's from the Privacy Commission or otherwise, and as part of the consultation process that can support you with this process. So a couple of things I will highlight in terms of preparing for IPP3A. And the first is really about building a collection register. You don't have one, or refining your collection register so that it is proactively aligned to the change landscape coming up. So making sure that you've documented every instance of personal information collection, and that you can clearly distinguish between data that is collected directly or that is collected indirectly as well. Also important to evaluate the methods that you have used. So, being able to understand whether it does come from primary activities or indirectly through aggregated sources or secondary research, for example. And then finally, it's essential to integrate these practices across your regional offices and maybe service delivery teams, so that that collection register is embedded in your standard operating procedures. Now, this consistent approach will, of course, help build transparency and ensure your compliance with IPP3A once it does land. Now, secondly, making sure that you can very, very clearly identify between those direct and indirect data sources. So again, analyze how data is collected for direct data sources, those primary activities, and then, of course, the secondary activities for indirect. A useful question to ask yourself is, did the data come straight from some original observation, or was it compiled from other sources? Make sure to review metadata and associated documentation. So for direct data sources, they might have comprehensive metadata, including collection methods, dates, instrument details, etc. But with indirect sources, you might have references to other studies or sources. And then finally, perform cross-verification. So compare the data you've got against independent sources, and make sure that you've done careful contextual analysis to confirm the reliability of data that you do have. Now, finally, reviewing for exceptions and compliance risks. So make sure that you've mapped your systems, processes, and applications that do collect or transmit personal information. Make sure that you've reviewed and validated any policy exceptions, so exceptions that are there against the statutory requirements, but also any internal policy exceptions you might have in place as well. And then obviously, it's important that you have got a comprehensive risk assessment and remediation strategy, and then use that to assess your potential compliance gaps by evaluating the likelihood and impact of risks associated with data exceptions or misaligned practices. So really, by doing all of this and having that effective consultation process in place, organizations can not only meet the requirements of IPP3A, but start turning their privacy transparency into a competitive advantage and increasing trust and mitigating risk.
Yeah, brilliant. I think that one of the things that we're looking at today is clearly potentially a complicated issue, but I think it boils down to the information that we have around other people, how we got it, why we have it, are we allowed to have it, and how are we allowed to use it. I think when it boils down to it, it's a relatively simple set of questions. And of course, the application of dealing with that information can be, as we can see on the screen, relatively complicated. But hopefully today, Kiran and Rohit will steer a clear path through to getting an idea of what compliance looks like. I might turn to Rohit now, the next slide. about what next steps might look like for organizations who are caught under this.
Right. And I think Kiran did touch upon the resources which are available on the Privacy Commissioner's website, as well as the business adoption methods, which is which was quite comprehensive in that sense. But and just an extension of that from what are the practical next steps. Just what Kiran mentioned earlier in terms of having that this register of data collection. One of the ways to do that would be conducting a privacy audit in terms of understanding, mapping how you collect the personal information from third parties, including databases that are purchased like from marketing firms or data sharing arrangements or outsourced services. So you need to identify both direct and indirect sources of collecting that data and how that information flows into your system. So that gives you a clear roadmap, and then or rather a map of your data flowing in to your systems. And then the next step is, when you are aware, it's more about not remaining non-compliant, which means the next step would be to notify individuals to make sure that they are across that, how the data has been collected, and also letting them know through direct emails, online notices, customer onboarding process. The key element, it has to be done in a timely and a transparent manner. The third piece is that what I would like to call out is the privacy policy and the process, what we spoke about earlier as well, that we need to be consistent in our process and practice. So the idea is having the privacy policy and procedures updated with covering the indirect collection of information under IPP3A. That would reflect that and interconnection between what we are doing and how and on the basis of that. And lastly, it's all not leaving out. It's also about creating that obligation back into our third-party vendors, whom we are collecting information, whom we are getting this, who is the major source of this information, that so that it doesn't impair. It's not uncovered or left there. It is more about having that contractual clarity around the data sourcing, sharing responsibilities, and compliance obligations. So it's not just us who is taking the charge. It's about also making the collecting agencies aware of their obligations. So by doing that, you will be able to cover end-to-end view. Yep. What do you,
Yeah,
Michael?
thank you. And I think that whenever we're dealing with issues of complexity like this, where there's a lot of moving parts, there's a lot of inputs, and there's a lot of potential ways that those inputs can be confused. I think that what we're hoping to do today is give you a sense of that, where there is a lot of swirl, being able to overlay a structure that is able to be consistently applied, an understanding of what the policy drivers are, and then understanding how the procedures that you build into the organization are informed by those policies, such that for all of the circumstances that you might encounter, the structure that you've overlaid over top of that is capable of addressing each and every instance of where you might encounter elements that where 3A might come into play. Now, speaking of privacy principles, we might move on to the next slide and have a look at some instances where IPP3 has come into play, and there have been some instances where now I might talk to Kieran about some instances where that's happened and what lessons learned might be appropriate.
Sure. And what I'll do is just quickly go through a couple of these cases and just identify some high-level takeaways in terms of doing the analysis, and then I might pass over to Rohit to go into a bit more detail in terms of what can we really take away from doing this analysis. I think the key thing is that what we're about to cover isn't necessarily about IPP3A in particular, but by looking at these kinds of case studies on what has happened, you can get an understanding of, with collection of personal information, what can go wrong, but also, what the implications of that might be. So turning to the first case study, and this specifically related to if we kind of look at the first case study that we had before. Now, in this first example, we had a a local council that published a resource consent application online, but also along with the email exchange with the person that was actually party to that resource application. And those emails included sensitive details such as her disability benefit status. Now, in this particular example, the council didn't clearly notify the applicant that that correspondence would be made public, and the notice on the consent form wasn't really considered sufficient since emails were collected before the application was submitted, and also they couldn't really justify that publication based upon statutory overrides under other legislation. Now, in this instance, an apology was given, the details were removed, and this will be a parallel across the other cases that we've got to look at, there was some level of financial settlement that was entered into. So I think the key thing is that when things do go wrong, it's important to understand what the potential consequences of that might be. And this case really does underlie that even when there might be an obligation to publish after collecting, it's important to understand the notification and disclosure requirements that do go alongside that collection process. Now, looking at another example, in this instance, there was a bank that conducted a credit check on a couple during a joint account application process, very standard process. Now, in this, their personal details, including employment information, ended up being passed on to a credit reference agency, which was not considered a necessary step for the credit assessment. Now, the absence of a positive act of authorization meant that the bank inadvertently breached both principles 2 and 11, actually, in terms of collecting and disclosing that information in a way that was considered unnecessary. So this case really demonstrates that it's important for organizations to secure positive and informed consent before they do perform actions that might involve information, and that might be relevant for us a bit later in terms of looking at how the landscape might be evolving in terms of particular kinds of sensitive information. Now, looking at the third example, we had a woman that applied for a government job, and the expectation was that only her nominated referees would be contacted, but actually the government department involved also reached out to a former employer who provided a written reference without her explicit consent. Now, in this instance, the department failed to notify applicants about its broader policy of contacting referees or additional contacts sourced from the references themselves. And while the information itself was directly related to assessing suitability, the breach under Principle 3 was considered quite clear. Now, this highlights that it's critical for organizations to not only clearly inform applicants how extra materials might be used in terms of those secondary information, but also to secure proper consent and also to communicate policies that might be in place, and to also align those processes to make sure there is trust with consumers. Now, I've obviously talked about a couple of key takeaways and interesting parallels between these particular examples, but Rohit, I'm very keen to get your insights on this in terms of what you consider to be the key takeaways from analyzing cases like this.
No, thanks, Kiran. And I think one thing that we need to all appreciate is this is real. These are actual cases that have happened from the IPP3, which means that it is going to be applicable once the IPP3A is also applicable. So these are the lessons learned that we should consider and try to embed these compliance requirements into our privacy programs. Now, the common themes that we have been seeing across some of these cases is consent is critical. Where appropriate, we should seek and record consent. But what we need to remember now is that consent is not a substitute for notification now. It's complementary. So notification is also a must. Transparency matters for individuals don't know that what's happening to their data, trust erodes. So clear upfront communication will be non-negotiable. And those are the things that when we imbibe them in our processes, it's not like we have to do something extra here. We actually do it as a business as usual. Surveillance requires justification. Now, just because you can collect data doesn't mean you should. So it's about justifying any form of monitoring, whether especially in public and sensitive environment. Third-party data collection and sharing needs oversight. Now, that is very critical because any onward transfer of data within entities must be disclosed at the point of collection. So this is going to be critical. And one of the things for our future IPP3A requirements as well. Data reuse must be lawful. What we're trying to see here is that just because we collected data for one purpose, it in a completely different context without consent, it cannot be used for another purpose, because that constitutes for a breach, which is what we learned from some of these cases. So these are not lessons about just compliance. This is about building a culture of data ethics and accountability, right? It's about the spirit behind upcoming IPP3A is just extending these expectations about, how would those be implemented in an indirect data collection too. So these are the lessons learned, but we can definitely see how the same could transfer when IPP3A gets implemented. With that, I'll pass it on to Michael.
Thank you very much. And I think the point that you made about just because we can doesn't mean we should is a fundamental one. I think that the relationship that we have with corporations and government is one that's always mediated by ethics which are enforced by legislation and regulation. Which means that what we're trying to do is, I guess, establish some sort of power balance between us and the organizations that we deal with on a day-to-day basis. Again, that point of when that power imbalance sways too far in one direction, where all of a sudden the distinction between can and should disappears, I think that's where this kind of legislation brings that power balance back to something approaching parity. And it's a really, really important point to make. Now, what we might do is move on to the next point, which is a fascinating next step around privacy. And it's a discussion around biometrics. Over the course of the past several years, biometrics has become more and more a part and parcel of the way that who we are is, and physically who we are, is embedded in other people's databases. And I'd be interested in your thoughts around what's happening in that particular space in the context of privacy in New Zealand. What I might do is turn to Kieran about what the biometric code looks like now.
Thanks so much, Michael. What I'll look to do is just give a brief overview in terms of what the proposed code looks like and some high-level, I guess, key elements that it looks to cover in terms of information technology and usage, and then I'll pass over to Rohit to really dig into the key risks that these kinds of changes are aligning to. But as Michael clearly indicated, we're seeing the potential for significant change in relation to how organizations handle biometric information. So what we're seeing is that there will be a specific biometrics code that will sit alongside the Privacy Act, but introduce more detailed and targeted rules for managing biometric information. So the proposed biometrics code is designed to specifically govern the use of biometric data. Now, while the Privacy Act, of course, covers personal information in general, biometrics, due to its sensitivity and direct link to physical or behavioral identity, it's pretty clear that it needs more bespoke protections, and that's where we're seeing the code come in to align to that. So the code will cover some key areas, including the reasons for collection of biometric information and, of course, governing how it'll be used. Guidelines on how and where biometric data should be stored securely, as well as rules defining who can actually access this data. And then, of course, specific rules on sharing of biometric information as well. Now, given that biometric information can relate to unique physical or behavioral characteristics, it's considered that these detailed stipulations are essential for minimizing risk. Now, we expect the code to come into force later in 2025, but organizations that are already using biometric technologies are expected to have a bit of a grace period. So, of course, the rules will be binding. There'll be a bit of a period to transition existing operations into full compliance. Of course, the caveat to that is that even if there is a bit of time to get processes aligned, and of course, we haven't seen the code come into force yet, it's important to make sure that you're preparing in advance for regulatory changes coming down the line. Now, the code will emphasize that biometric information, whether it be a person's face, fingerprints, voice, keystroke patterns, all of this should be handled with extra care, befitting something being so sensitive. Now, technology such as facial recognition, they and various other technologies, they can clearly fall within the scope of the code and require that additional protection. Now, so a couple of key things that the code will include, and I'll definitely let Rohit go into a bit more detail on these, but it will require proportionality tests and implementation of stronger safeguards, particularly if you're operating that kind of technology. Enhanced notification and transparency obligations. Organizations are expected to be very clear on how they assess the pros and cons of using biometric technology. And then there are some trial provisions as well in terms of allowing organizations to assess the impact of biometric processing before full-scale implementation, kind of aligned with what I just said before. So it's really important for organizations to start reviewing their current biometric practices to prepare for compliance so they can ensure that they're integrating robust privacy safeguards and to maintain those high levels of transparency consistently throughout their operations. But Rohit, I'll hand over to you now, maybe to dig into a bit more detail on those key risks and what rules align to those.
No, thanks for that, Kiran. And I think we all will agree that why there was a need for the dedicated code. Simply put, biometric presents a high impact risk. And why is that? Is because there's a lack of informed consent. Individuals may not be fully understanding what's being collected and how is it being used, because it might be collected through various sources. There is a functional creep in terms of data being collected for one purpose may be quietly being repurposed for surveillancing, profiling that you touched upon, Kiran. And other aspects is security vulnerability, which means that, as you can imagine, if compromised, we can change our passwords, but you can't change biometric data because that's going to be permanent. And the risks of all of this is the risk of discrimination is bias. The biometric systems, especially the facial recognition, can exhibit systemic bias against certain groups. So given these risks, the code is designed to ensure that biometric data collection is justified, transparent, and ethically governed. That's, I think, the key broader message. It provides some much needed regulatory scaffold for technology that's rapidly outpacing our existing rules, right? Like, because there's so many use cases of it, it's very hard unless you have a good regulatory remit to make sure that we follow the right rules. So what are the rules aligned to these risks? And we just covered it and touched upon at a high level. One is, justification and necessity. The agencies which are accessing this using biometric needs to see the proportionality test that we spoke about, that what problem are they trying to solve. So that's very important to move going forward when you're collecting that information as businesses. Transparency is the key. Clear signages, easily accessible public notices. I think these are a very key way or very easier way to make sure that everybody's aware. Data minimization, again, I think this goes without saying that use the data as necessary only for intended purpose so that it's not misused. So I think that needs to be covered both in policy and practice. Prohibition of using it for profiling. I think there's a big boost given to make sure that, or rather emphasis provided that rules prohibit biometric classification for the purposes like including profiling. It's whether it's about using individuals' health or talking about physical state, etc. It's about making sure that there is no risk emerging from them in terms of using this biometric to categorize them into various race, ethnicity, etc., and so on. So, and there's some other rules as well around risk assessment, retention, security, access rights, which is more for safeguarding the data being collected. However, to summarize, collectively, these rules aim to create an ecosystem where biometric data is not only regulated but respected. I think that's the message. Again, transparency around why it's collected, how is it going to be used, and safeguarding the data is what's going to be critical going forward. Kiran, I would like you to just touch upon how does businesses, get ready now that we know the rules, we understood the risks behind it. How do you suggest that businesses can get ready for such a change?
Yeah, sure. Thanks so much, Rohit. And I'll walk through this in an expeditious way because I think that we've touched upon these in relation to other areas, and there's also general application on some of the, I guess, the operational changes that can be put in place. But again, preparing in advance, it's important for organizations to take a multi-step approach to getting ready for these changes. So first up, organizations should start by evaluating if they're collecting biometric data in what instances and whether that collection and use is justifiable and proportionate to their specific needs. So making sure to assess risk and necessity, and then implementing robust safeguards. So strong encryption protocols, regular security audits, and strict access controls. And then, of course, communication is key. So that's all related to ensuring that you are following strict notification requirements and being transparent. So making sure you have clear policies for notification when biometric data is being collected, being transparent in terms of providing accessible and comprehensive information on use and protection, and that will ensure compliance, but also build trust. Establishing clear boundaries, very important, particularly in these kinds of high-risk areas. So making sure to define what constitutes fair use of biometric data and then enforcing limits rigorously to ensure that ethical practices are upheld and also to prevent misuse. Protecting sensitive data means that you need to control the flow of that data, especially if that data is going into is going to other jurisdictions that are outside New Zealand. So key things to bear in mind in terms of how that information is being disseminated. And then finally, reviewing and adapting any web scraping policies you might have. So reassess those to ensure they align with the new biometrics code, adapt them and put particular restrictions in place to balance compliance with your practical needs and ensure that even ancillary data collection methods don't conflict with the stricter biometric regulations once they do come into place.
Yeah, thank you, Kieran. And again, I think that the point that's being made overall here is that fair use, I think, probably sums it up. Why do we have this? How do we have this? Do people know we have this? Now we're using it appropriately. Again, it sounds the application in practice may be complicated, but in principle, it's a relatively straightforward process. Now, what we might do is move on to another aspect where, if we can move on to the next slide, where some Australian concepts around consumer data rights gradually moving their way across the ditch. CDR has been in place in Australia for a little while now, and is gradually expanding in scope to pick up more and more industries. And I believe there is still some discussions that might be advanced by the new government over here to see whether further industries might be caught under this regime. But look, what I might do is ask Kieran to talk to us about what CDR is and how it might play out in the New Zealand context.
No, thanks for that, Michael. So I'll just summarize it very quickly in terms of what it means for us. So under the CDR, which is Consumer Data Rights, which is regulated under the Draft Customer and Product Data Act 2025, New Zealand government's it's an open data initiative. It allows consumer to safely share their data with accredited third parties, which you are referring to earlier, Michael, as in specific industries, say from the banking sector, which is expanding to the energy sector and beyond. The example is that all the consumer transactions, histories, their information, which is all termed as consumer data, can be passed on seamlessly, safely to the next provider and shared with consumers' consent. What it means is customer now data holds enormous value and an opportunity, but only if customer can make full use of it by having also being able to empower consumers to have more control over their data while enhancing market competition and product innovation. Essentially, for businesses, it means that building data portability mechanism, stronger consent frameworks, and robust security protocols. So that's in general what consumer data rights would be. But I'll just pass on to Kiran to talk more about how businesses can prepare for this.
Thanks so much, Rohit. And yeah, I'll do the same and try to go through this as quickly as possible in terms of how businesses can prepare. But again, it's important to have a multifaceted approach in terms of balancing your compliance with long-term business growth and innovation. So a couple of key strategies. Make sure that you're assessing and allocating your compliance cost in terms of where it might be most needed in terms of having that uplift, making sure you have the right budget and resource allocation associated. Making sure that you're enhancing data security and consent management, so updating security protocols, revising consent management, and of course, making sure that you're investing in staff training, making sure that you're fostering innovation and supporting product development, which is a key element of these leveraging of consumer data, and also that supports facilitation of competition and product enhancements. There's a key focus in terms of customer outcomes, so making sure that you're utilizing consumer data effectively in terms of how you might be tailoring your products and services to them. And then overall, that can align to improve customer satisfaction and loyalty. A key thing with CDR, and Michael did touch upon this before, is that it is a framework that we've seen evolve over time in Australia. So it's important to continue staying informed of these changes, monitoring the evolving regulatory landscape, and adapting your strategies as needed to ensure that compliance and operational strategies are flexible, so that even once CDR is in place, that you are ready to adjust if there are any changes to the framework or new industries that do get added along the way.
Thank you, Kieran. Now, we might move on to the next slide, and I think it's a really nice segue from what we just saw about the Australian CDR regime, and as that's elements of that are flowing across New Zealand. But I think one of the things that we see, and again, I touched on it right at the top of the piece, is that there are a lot of organisations in both New Zealand and Australia that have really strong ties with colleagues and collaborators in the other jurisdiction. And I think that one thing that might be worth exploring just a little bit is, given there are so many organizations that do straddle the ditch, how they might go about looking at making sure that their privacy obligations are more easily aligned and more easily managed, given to similar but not always identical regimes like CDR or the privacy principles. So what I might do is invite Kieran to run through that for a moment for us.
I could probably spend an entire webinar just covering off on recent Australian privacy reforms, but we don't have time for that. So this is going to be a bit of a whistle-stop tour in terms of looking at what has changed over the last couple of years. And I guess a couple of key interesting things that have happened over in Australia, that if you obviously have cross-jurisdictional activities or cross-jurisdictional data flows, you need to be ensuring compliance with anyway. But it's important to use it as kind of like a horizon scanning measure of seeing what changes are coming into place or are coming into place in Australia that might also be seen coming into play in New Zealand down the line. Expanded consumer rights is a really good example, because we've obviously talked about it as a key focus area today, but we've seen consumer data rights expand to, and that framework expand to more and more industries over time, starting with financial services, but moving into telecommunications and other areas. So a key thing for businesses to be aware of is an understanding what is the potential likelihood of an expansion in that regime once it does land in New Zealand as well. A couple of key reforms that I've covered, there's a couple of them you can kind of read on the screen at the moment, but what we've seen in Australia is more protections around online safety and managing online privacy in that context, improvements around cybersecurity in relation to management of critical infrastructure in particular, but also expansion in cybersecurity legislation in general. We're likely to see more protections for around serious invasions of privacy, and that's been tied in with the privacy amendments that are currently being implemented in Australia in terms of amendments to the Privacy Act. And then what we've also seen is changes to civil penalties under privacy legislation. So what businesses can expect is increasing penalties over time in terms of non-compliance with privacy requirements. Now, Rohit, might pass over to you on this. What would you say are key responses that New Zealand businesses need to be making in terms of these regulatory
No, thanks for that, Kiran. I think it's about understanding that when we are operating in New Zealand, Australia, we need to have a future-ready privacy program that needs to be unified and with a risk-based approach. So it's all about, from our point of view, it's about harmonizing compliance strategies across jurisdiction, proactively applying higher privacy standard, which is best of both, and then creating one consistent privacy experience for your customers, regardless of which geography. It's about giving the best experience to our individual customers from their privacy point of view, that so that we create a building loyalty and fostering privacy-aware culture. Now, what's the roadmap from that point of view? We've just summarized it in 5 points. Of course, it's much more, but the idea is these are the 5 key themes. One is having a comprehensive privacy policy review. It's about making sure that we are having a one common alignment towards both regulatory reforms from New Zealand and Australia perspective. Having data governance framework is very key, which is mapping your data, updating your policies, assigning ownership, who owns the data. Then it's all about information security, the securing the data, which is following the global practices, uplifting your cyber resilience. Also, what's critical is, and has been seen a very critical point from a regulatory standpoint, is the international data transfer. So it's about third country disclosure, implementing standard contractual clauses and binding corporate rules. And last but not the least, it's continuous improvement. So as you had mentioned, Kiran, earlier, it's not static, it's going to be ongoing. So it's all about training, continuous audit, and automation. So the roadmap is not just about ticking regulatory boxes, it's about building a sustainable, trustworthy digital future, given that we are seeing that emerging regulatory reforms in the privacy space. With that, I'll pass it on to Michael.
Thank you very much, Rohit. Look, I think we might move on to the next slide. And I guess one of the things that we've tried to touch on today is that there is a lot of movement in this particular space, and it's not unique to privacy. What we see here today is an element of broader, significant regulatory reforms that are coming in response to cultural expectations and changing cultural expectations. And we might move on to the next slide to discuss a little bit both how LexisNexis and Diligent can help you manage those regulatory reforms in a way that's appropriate and effective as well. So first, I'll invite Robert to talk about how Diligent can help.
Yep. No, thanks for that, Michael. So as Michael alluded to, it's all these changes can be overbearing, and we do recognize that. And as a GRC SaaS provider for managing your regulatory compliance program, we recognize the need that customers need more access to consume very wide variety of regulatory content, and hence we have entered into partnership with LexisNexis. And what it means is with Diligent One platform, you can gain access to LexisNexis rich data and regulatory alerts to be across all these changes with the API that's already in place. Now, using that content and several out-of-the-box frameworks that we house in Diligent One platform, you can now automate your entire compliance monitoring and reporting end to end. Now, there are several other AI-based features that we are building in on the platform itself, so that it's made available as part of your compliance journey. And what this means that regulatory obligation databases and suggested controls from LexisNexis directly mapped onto Diligent compliance and audit control platform would enable you and businesses to demonstrate compliance from the get-go and benefit from a unified holistic solution. Yep. And I'll pass it on to Kiran.
Think that I'll keep my response really brief because Rohit, you've just given a great summary of how our two solutions can integrate so well together. I think the key thing for myself is that the content that we're delivering in terms of our extensive regulatory databases, our tracking and notification function, as well as our capability to provide content across jurisdictions with our global offering, that really does create massive potential when our solution is integrated with powerful solution lines like Diligence via an API feed to ensure that you can see that alignment between our content, but also with the power of that technology backing that up.
Yeah, exactly. And I think that one of the great benefits of this relationship is that we have experience in both content and delivery. And I think understanding from a customer's perspective what we can do to make it easier for you. I think it's never going to be easy. It's never going to be click the button and everything's fine, but at least we work with you in a collaborative fashion to understand what we can do to smooth out sometimes lumpy processes. Now we might move on to the next slide. We had hoped to give you a tour of the LexisNexis regulatory compliance solution. We have come quite close to time, and we have some fascinating questions in the chat that I'm sure Rohit and Kieran are desperate to answer. Given that, please get in touch with us if you would like to have a look at the way that LexisNexis provides you with insight in terms of those obligation registers and those regulatory change pieces we touched on at the beginning of the piece. But let's get back to the meat of the webinar today. So the first question, in fact, we've got a number of questions from a gentleman by the name of Richard Johnson. First question, and I'll point this to Kieran. The government job application with the non-nominated referee, do you know what the outcome of that was?
Yeah, as I said before, the outcome across all of the case studies is that there was a finding of breach of one or multiple privacy principles, which resulted in a finding against whether it was the government agency or the particular organization, and a settlement was entered into with the applicant. So that was the case in this particular instance. There was an apology given by the department and a settlement reached with the applicant. But the key thing was that what led to that finding and the settlement being reached was the finding of breach of privacy principles, particularly around openness. So the failure to notify about that policy of contacting referees. So it's a specific example that breach can arise from multiple different contextual instances, but it's a really good illustrative example of what can happen and the consequences of that.
Yeah, and I think all three of the examples that we saw cited weren't malicious. They were accidental, a misunderstanding or a misinterpretation of procedures to follow and how policies are applied. So I think, again, it comes back to that sense of, just because we can, should we be doing this? And that's the question that we should all ask when we're dealing with what's effectively other people's private property, being their personal data, or in some instances, their biometric data. Another question from Richard, and this is fascinating, I might turn to Rohit for this one, is there a gap where biometric technologies are not being used, but biometric information is being collected? So facial images being captured, but not used with biometric technologies, or potentially yet. So I guess, and again, Richard, I don't want to speak on your behalf, but it's a fascinating question. Let's say, for example, and I think there was an instance that we saw, one of the examples we were talking before we settled on those three, of someone being accidentally photographed in a photo shoot, and eventually their image went live without their consent. So I guess for me, there's two questions. One is, how was that dealt with? And the second is, given that photos are now widely disseminated online, and could those photos then be perceived through the lens of biometric technologies down the track? So, Kieran, I'll talk to you to the first one about that instance where I think a council took photos of someone watering their lawn for other purposes, and they were fined, I think, weren't they?
Yeah. Again, it's a similar instance where by doing that it was not there was a breach of the principles in terms of doing that collection and doing it in an unauthorized way. So I think it is a really good additional case study that does align with that example.
Yeah, and Rohit, to you, if let's say, for example, our unauthorized water user in a New Zealand local government area was accidentally photographed, and then their photo was posted online, as I believe it was. Given that we now have biometric technologies that are capable of parsing through photo libraries, what are the consequences in terms of privacy that you see flowing from that?
Yeah, I mean, this is a scenario, right? And these scenarios will keep emerging as technology updates, and we are able to see this upcoming. As of now, I think there is no clear guidance around whether this would be covered. But having said that, it's still a privacy breach from that point of view. So the similar regulatory regime will apply. It's just a case-to-case evaluation, if I may. So there's no clear guidance in terms of what happens if the biometric technology is able to assess this information which was available online, and then it means that that data has been used for some other purpose using that photo being there online. But having said that, the same rules apply, which means that once you collect that data through biometric technology, and use it for some other purpose, the code would be applicable to you. And that means that, you have used it without consent, you have used it without the knowledge of the individual. And that could mean that you are, you may have to justify why you're using it, and whether, the individual is aware that that data is being used without their knowledge, and there's no notification provided. So these are all part of the rules. So essentially, it's about making sure that however you source the data, you need to make sure that these all requirements have been met. with respect to notification involving the individual and making sure that they are aware that this is being used for this purpose. So that's what I would suggest at this point.
Yeah, absolutely. And I think that elements of that are playing out. I believe there's some new legislation around deep fakes in Australia, which of course then leans into a lot of the topics that you covered there. Look, we've got one more question, and again, it's a really fascinating question with a lot of broad application. So it's from Srinavan Varanasi. What's your advice in relation to treating data that's moving into archival storage when it comes to compliance, especially CDRs from ANZ perspective? I might invite you both to speak to this. Kieran first.
Yeah, it's a really good question. Trying to think of how to keep this one brief. So obviously, data security. So making sure that whatever archival storage solution you are using has, robust security measures in place. Make sure that you've got very clearly aligned data retention policies to that. So how long is it staying in storage for? How long are you keeping it for in there? And then, of course, that helps in terms of managing your storage costs as well. And then, of course, regularly monitor the use of that system to ensure that you are continuing to meet compliance requirements, particularly with CDR as it does evolve. How that information is being accessed and retrieved, that's also an important thing to think about. And then, of course, throughout, and we've talked about it a lot today, making sure that you're transparent with consumers about how data is being archived and used, and making sure that you're providing clear information in terms of your rights to access, correct or delete information. And all of these things, if you're using further advanced technologies, then it's important to understand how that use of an advanced technology might affect all the things that I've just mentioned.
Brilliant. Thank you. And Rohit?
No, I think Kiran covered everything, to be honest. Michael covered all my thoughts there. So I have nothing more to add in this case.
Alignment's a beautiful thing. All right, we might move on to the next slide. And please, thank you all for those fascinating questions. There is nothing that brings more joy to this team in particular when we're presenting webinars to know that we've got an engaged, interested audience listening to us. What I might do is first start with Rohit to share your closing thoughts, then I'll pass to Kieran.
No, thanks for that. Three things that I would like to leave you with is go beyond compliance. With a unified GRC, build brand and trust and agility. What we are trying to say is embed privacy and compliance in your culture as far as the organization goes, supporting business agility and protect your reputation and strengthening stakeholder trust. Second piece that I would like to call out is the demonstrating compliance from day one. So, with the suggested controls that you get from LexisNexis, along with the regulatory requirements and with the leading practices which are mapped in the diligence environment, it's helping you demonstrate compliance immediately and confidently. And the third piece is future-proofing your privacy program and compliance program. What we have learned today is privacy is not static. It's for businesses to be successful. It's imperative that you embed it on an ongoing governance with robust data management and automation so that you can create a resilient and a trusted digital future. Yep, I'll pass it on to Kiran.
Thanks so much for that, Rohit. Look, I think that in terms of trying to sum up everything that we've covered a lot of pretty technical legislative amendments that are in play, whether they be in New Zealand or across in Australia, but really they challenge all of us to build a privacy first culture. So going beyond mere compliance by really focusing on how can we be as transparent as possible and be as clear in communication as possible by reviewing practices and setting up clear notification procedures, updating policies, training staff. There's really a path there for businesses to effectively manage data collection, whether it be generally or in relation to other specific types of information as well. And it's very, very important to maximize stakeholder engagement throughout the process so that of evolving regulatory changes so that you are continuing to create a robust privacy framework that is driving cultural evolution and improvement across the organization.
Yeah, look, thank you both. I think that today, as you mentioned, there was a lot of technical detail. We'll be sharing a copy of the slides and the recording to everyone who's registered today. If you need to drill down into a few elements that we may have warrant further review, please have a look at the QR codes and the links that go to those for a little bit more information about LN and Diligent. And again, thank you all for your time and your participation today. one of the reasons that we do enjoy presenting webinars like this is the feedback and the questions that we do get from audiences like you. So thank you again for participating in today. And we look forward to hearing from you if you have any further questions around either what Diligent can do to help, or what LexisNexis can do to help, or perhaps both. Have a wonderful day.